Good morning, Tawani. Can you hear me? Hi, Tawani.
Ibanala siya pagkatapos. It's right. Mute.
Je kan hier aanslaan.
Why don't
Just look at your picture that you know.
good one? Allow me, on behalf of the Commissioner of CIPC, Advocate Rory Voller, his executive, and the entire CIPC family, to pass warm greetings on this beautiful morning, whereby through this webinar, we're celebrating the 10-year anniversary of the Companies Act 2008. Let me take this opportunity to firstly remind all of us participating to kindly switch off your microphones to prevent background noises during the webinar, and also switch off your video cameras, as that could also affect the quality of the broadcast. In terms of Section 185, subsection 1 of the Companies Act 2008, the Commission is established as a juristic person to function as an organ of state operating under the umbrella of the Department of Trade, Industry and Competition. The Companies Act 71 of 2008 has brought fundamental changes that affects the operations of companies and its directors within our economy. The Act itself established the Commission, which was established on the 1st of May 2011, hence the celebration today. Allow me, as one of those, one can say, have been there before this journey. Before the merger of SAPRO and SACRO, which gave birth to CIPRO, really I must confirm to you that computerization through presentations that will be provided to you, you'll realize that it took us out of the dark ages to this beautiful journey that we traveled these 10 years. I recall a very intensive, labor-intensive seal machine that we used to use just to put a seal on registration of a company. I recall us being on the media so many times for wrong reasons. Some saying just for a mere change of director, taking them 2 months. Some saying documents are missing, not forgetting that we were dealing with a lot of paper. Hence, uninvited guests such as your cockroaches were always with us. That is the reality. And today, I'm proud to say that being part of this journey, we do know that the Act itself has created a conducive environment for us as employees, as well as the business community. Allow me to also quote a statement by the former CEO of CIPRO. I quote, "This never-ending backlogs, while you are all running like headless chickens, I'm tired," unquote. Yes, we have a lot to celebrate. Allow me to also share with you or present to you the head of a truck that delivered this massive, great achievement of our organization. I present to you our Honorable Commissioner, Advocate Rory Voller. Over to you, sir.
Thank you very much, Marumo. I hope you can all hear me. Can you hear me, Marumo?
Yes, we can hear you.
Thank you very much for the opportunity, and also thank you for the wonderful journey and opening words that you have presented to us this morning. My job is but a simple one. I just want to give a quick synopsis of where we've come from, and also to add on to the words of Marumo about the journey that we've undertaken. Firstly, it's hard to believe that it's just over 10 years. Can't call it new anymore, but we are still 10 years later, still getting to grips with many of the revolutionary, I would say, and evolutionary and best corporate practice worldwide that is contained in the Act. We at the CIPC, we certainly take pride in this fact that we have made great strides in carrying out the intent and purpose of the organization as contained in this piece of legislation. And by far, the Companies Act is a very complex, it's a very wide-ranging, and it's a very long piece of legislation for one to get to grips with. It takes people years to do it. From our old Cipro days with its bureaucratic and archaic systems of dealing with registrations and maintenance of companies, to the new CIPC, Companies and Intellectual Property Commission, the great movement from being what I've always termed over the 10 years, the movement from a registrar of companies, paper pushing and doing all of those administrative tasks, to one of being a regulator of companies, which is certainly one of the policy directives and what we wanted to achieve when we went about doing and dealing with this piece of legislation, which, by the way, took us 10 years to complete. That's how complex it is. We have seen the use and explosion of very major changes from judicial management to a new business rescue regime. I'm sure many of you have seen that. You've seen how SAA and all major companies have entered into that regime simply because we've entertained the Companies Act and we wanted to see these new things working. Ever so present, this business rescue regime has been, and especially timelessly because of the pandemic and the economic issues that we've had and still having because of that. And the fact that we could have had such a great evolutionary, futuristic, world-class turnaround system in business rescue, you can see that the wealth of jurisprudence has been built up. You look at the courts, you'll see that majority of company acts that come before and company legislation acts that have come before in terms of it, a lot of it has to do with business rescue. And but what it has done, it has strengthened its impact, and it has certainly met its intent. We certainly remember the days when it took weeks to register a company, as Marumo was saying. The use of shelf companies we have seen, we don't even see thousands and thousands of shelf companies being registered anymore. Some still hold on to that old regime, but we don't see it because we have such big turnaround times. We closed the gap for quick and easy registrations, as you know. Turnaround time of a new company registration is now being measured in hours, not even in days. And we're certainly proud of what we've achieved and what we will continue to achieve. If we look at some of the aspects on the regulatory front, The CIPC has made meaningful contributions in investigations because we've always went out and said that the core values of what we want to do is to enhance the regulatory and the corporate environment in South Africa, and therefore we need to be a credible investigating unit and a credible enforcer of company law. And we dealt with large matters involving, if you look at some of our historic matters ended up in court and stuff like South African Broadcasting Corporation, the SABC. We looked at Telkom, we've done some massive work around that. We look at SAA, we look at Steinhoff. We were the first regulator to move on Steinhoff, by the way. We were called to Parliament and asked to, many regulators were asked what has been done. At that particular moment in time, CIPC put our hand up and said, we have issued them with a compliance notice. Some of the tools that we have in the Companies Act that allows us to do these things. We've had major other ones involving in a nuclear regulators, and it's wide and far. But we don't only deal with big matters, we deal with smaller matters as well. To name a few, every day, single day, we are assisting companies with corporate governance matters and failures, requiring speedy help and speedy resolution. And we also work with our sister body, not really because they have oversight over us as well, but we work closely with them to try and improve the environment. And that is what is called the Companies Tribunal. Another body that we've envisaged in the law, and another body that is doing some good work. We should go out to use them. Just some historic, I recall the days when we practically lived in Cape Town, many of us on the drafting team. When I say lived in Cape Town, we were there for years. I would fly in and fly out on a weekly basis. Basically, I lived in hotels, and we would go to Parliament on a daily basis. I'd like to have a shout out for those who made this possible. The Deputy Director General at the time, Zodwa Mtuli, who is now the BE Commissioner. Prof. Mongalo will speak a bit later, a very eminent professor in company law globally. Advocate Flip Dunga, who's retired, great regulator, as well as a great draftsman. And McDonald Neshitenje is still with the department. We would draft until wee hours of the morning, get 2 or 3 hours of sleep, and maybe we would be back in the portfolio committee of trade and industry presenting what we've done. And this would go on day by day because we knew the importance of corporate and company law and bringing our legislation into the first world. I think we've done quite a good job, but there's more to be done. Indeed, we didn't get everything right. I must admit that. The reason why it's 2008, but only enacted and enforced in 2011 is because it was a strange thing. So much errors in them that we had to amend an act that never came into force. So 2008 became 2011. We never got everything right. And there's still aspects of that we need to amend, and we're going to go through the process of amending as we speak. But we're proud of the fact that it was inclusive. It was a very, very highly consultative process with a wide range of stakeholders, wide range of forums, eminent legal minds, eminent practitioner minds in the accounting and legal field and beyond in the company secretarial aspect, looking at listing requirements and all of that. And therefore, we believe that the working of the company's law touches on everyone's lives. And therefore, we had to be open, consultative, transparent, and most importantly, we had to be inclusive in our approach and in our policy. I recall sitting in a dining room table after that, hurriedly working on Advocate Dunga's house, trying to get the regulations out. Because it was imminent, the president was going to sign and he was going to act, the date for the implementation of the act was coming through. We had no form. So the form that you see in the Companies Act shows you how we do it. It was drafted on the table. Because we work day and night to ensure that we try to get the best of what we have and the best for you, the people of South Africa, and a working solution to make company and corporate law easier, simply for we wanted to make an improvement on the ease of doing business in South Africa, but also to make sure that we have an improved and enhanced and the reputational corporate governance environments and country that investors can certainly work with when they're here. The CIPC has over the years made many strides as well in the culture of being an innovative, automated and solutions-driven organization. The fact that we're having this webinar, we could quickly adapt to the pandemic. The fact that many of our systems are online, as you know, there's no paper pushing, speaks to the heart that we've had a visionary as well as a futuristic approach to how we're going to deal with our customers and clients. No backlogs. We do have glitches in our system, of course, because we have network issues. We work at IT, which can be unstable at once, but we're always enhancing and trying to do our best, and therefore we have some of the better turnaround times in government, I believe. Let's also look at our staff who have embraced the new normal of rapid and agile change. We've We have an agile organization that when we put our minds together and our hearts together to make the lives of the people of South Africa better when it comes to service delivery issues for the organization for which we run, we have our staff that come on board that work non-stop to ensure that we meet those deadlines that we want to do, and to put out innovative solutions that people in South Africa can be proud of, and our jurisdiction can be proud of globally, in order for us to ensure that we have world-class systems built in-house by a talented team of developers for which we play. Our use of collaboration has also paid off. We have a lot of dividends with our award-winning BizPortal system, as you see, one of our basket of services that we have. It has been recognized amongst peers as being an effective and highly digitized tool that affects the one-stop added services, and we continue to add. We have company registrations, we have UIF, we have compensation fund, banking service, to name a few, and year on year, we will add additional services. Just this month, we've added some services from SaaS that you can go out and look at some of the aspects contained then, and you will always have it. Because we want to build a capacity and capability where South Africans go to one place and get on with the business of doing business, not bogged down by government services. That is our mantra that we live by CIPC, and that is what we strive to every day to try and achieve. Don't always get it right. I will always say that. We will always have complaints. We have a very wide social media presence. We have people who say, well done, but we have equally people that say, you are very bad at what you do. And we take that to heart. We don't go and be defensive. We learn from our mistakes and we try and make things better, because we don't get everything right, but we have the heart and intent to make everything right. That is the journey that we've been on for the last 10 years, making things better for the people of South Africa. Something that I am passionate about, and something that the people that I work with, staff and management, are certainly passionate about. Our e-services portal as our primary system for processing applications has gone through many upgrades. We've just done an upgrade in the last 2 years, many iterations of it, in the last 2 months, many iterations of it. We're adding digital services in terms of digital payments, and we can already see the benefits of it. Benefits are showing through the fact that we are reducing our misallocations. Those who want to go out and use the depository system, please use the new payment system, because we want to cut down on that, and that bogs our call center, and therefore we have new ways of doing and new ways of working. If you look at how we've done over the years, last year we had a bumper year of registration, the most that we've ever had in the history of the organization. Close to 490,000 new companies were registered with a record turnaround time of less than a day for 99% of those applications. We do have applications that we can't do in that speedy time, such as non-profit, which we're going to bring on board, public companies, etc. Take a little bit of time in the back end, but the majority of companies are private companies that get registered within less than a day. If all the paperwork is done, if all the way that it is submitted to us in terms of the application process is done correctly, and the use of our automated systems, therefore you will get that quick turnaround time. And many have seen the benefits as far as that is concerned. This is the journey. This is what we've been striving to do, and this is what the Companies Act has enabled us to do over the many years. But as I've said, we never rest on our laurels. Our values, our culture, our continuous mantra of improving on our services is what drives us to do even better year on year. So if you do have a registration, for example, in one day, and I say this to my staff, every year our clients will say, okay, you've done it in a matter of a day. We now mean it in a matter of hours. And when you get to a matter of hours, they want it in a matter of minutes. And when you get to a matter of minutes, they want it instantaneously. And that's what we strive to do. We have a vision called Vision 2030, which is our strategic document that we live by, which speaks about an annual improvement on our services to make sure that we once again meet what you expect of us as clients, and make sure that you can service your clients and service yourself if you come directly to us as a customer requiring the services of the CIPC. We also at the CIPC not look only at our mandate as contained in law, but have taken on services way beyond what we're responsible for. If you look at, you can make BE applications in CIPC. We're not responsible as a BE commissioner, but we have systems that can allow that. You can have domain names if you want a website. Open up a bank account, and we can put you in contact with a bank. You can SARS, you can Department of Labor, and we're going to add additional others. That's why we can bring all these services in government and the private sector in order for us to ensure that we make it an inclusive, all-round application, ease of doing business portal that you will be able to deal with at the CIPC and beyond. All of this has been possible because when we drafted the New Companies Act, we were futuristic and we were forward-looking. And we put in measures in law that makes it easy and possible for us to do certain things at the CIPC to make your lives better. Once again, I state, we don't always get things right all the time. We fail sometimes, especially when it comes to managing queries, when applications don't go right, but be assured of our best intentions and service delivery always. I say that CIPC does things really well upfront when services happen and quick applications get done. But if there's a failure in that system, our response is not all that good. And therefore, this year, one of our biggest aspects that we will be working on is making our query resolution and response times better when applications do not go exactly as they should have done. Leverage off the service delivery standards and improve on our service delivery standards and give our pledges to customers and clients and the people of South Africa of that mantra of improving year on year. The Companies Act of 2008, certain policy outputs that I would like to share with you all. But the reason I want to share with you all is because we want to see if we are living up to what is said in the beginning. Because when you write law, you write policy, and the policy directs and dictates what you're going to put in the legislation. And therefore, we have to see if we met those that have been contained within the policy paper that we went to Parliament with, and Parliament agreed with, and we went to cabinets, and ultimately the president said, this is what he wants to see for the country. And we have to take stock of that to ensure that we have met those policy imperatives, and we have not put any impediments forward in order for us to meet that challenge. So one of the purposes that we had, and we made it up front, and people said, how can it be the case? But we said that the companies that must promote compliance with the Bill of Rights as provided for in the Constitution in the application of company law. People said, what does that mean? It's not human rights. What is human rights in company law? But we know that companies and environments are intricately, and communities are intricately intertwined. If you look at something like what we did with the Social and Ethics Committee, a very, very revolutionary aspect that we contain within that, globally recognized around the world, that what South Africa has in the companies that others should emulate is something that we look at the well-being of workers. We look at the well-being of the community. We look at the well-being of the environment. Don't harm the environment when you're running your companies. All has to be done into consideration of the Social and Ethics Committee. If you look at the regulations contained, what it says that the report must be, it speaks to International Labour Organization, environmental aspects that must be contained within that to ensure that the Bill of Rights and human rights and environmental rights are not harmed by the running and the regulating of companies. Not only by profits, it's also about other things. We also said in the Companies Act, the registration of a company is not only is a right, not only a privilege for a few. If we've done lesser things, moving capital requirements, making it zero capital for you to start. Before, in previous laws, you had to have a certain amount of capital to start a company in order for you to get limited liability. But in our law, it says anybody can start, and that's the reason why we use this as a tool for economic transformation and economic benefits and economic growth outside run companies and register companies. One of the other imperatives was to promote the development of the South African economy by encouraging entrepreneurship and enterprise efficiency. And therefore, that is the reason why we brought in aspects like the Companies Tribunal, financial reporting standards, other bodies that encourage efficiency in government and in running the companies. You know, we have a bogged-down court system. We want to try and make companies, if there are issues within those companies and regulatory issues within those companies, we have to make them better. And therefore, we try to revolutionize that by encouraging enterprise efficiency, by making the organizations that are responsible for company law and company regulation easy to be run, easy to be dealt with. We created flexibility and simplicity. As you can see, it's simple to start a company. There's no major issues. We put in memorandums of incorporation that are drafted for you. Majority of companies use those formations, and the majority of companies are maintained through that. And therefore, we make it easier in order for those companies to run and to be dealt with. We have to encourage transparency and high standards of corporate governance. If you put that, we legislated directors' duties and what they shall be liable for. We looked at the running of meetings. We looked at first world issues like round robining. We looked at whole aspects of how do you remove directors, how do you replace directors, and also how do you deal with whole aspects of how shareholders get involved with in terms of the corporate governance aspects. All right. Improvements in company registrations should not only work in isolation, because when we look at the efficiencies and the corporate governance aspect, we also have to bring it to the fact that we must encourage entrepreneurship through the use of intellectual property as another driver of company efficiencies and support. That is the reason why it's the Companies and Intellectual Property Commission, or contained therein, in order to have the full gamut that is required for you to utilize the tools in law so that you can get the benefits of companies and intellectual property, which is drivers of economic stimulation and economic growth. And therefore, we have that in-house. Our work in improving the corporate governance landscape through our education and awareness sectors, such as our speaking now and our webinars, and us going to the length and breadth of South Africa to speak about this, also contributes to it, as well as our investigation and enforcement units, who on a daily basis look at complex investigations, who make calls, who have the power to summons, and also have the power to improve on how we as South Africans and the investment community look at how laws are dealt with in South Africa as far as corporate governance. That is the contributions we make, and that is what we continue to strive to do in the development of corporate company law. We have to look at how companies behave, and therefore we have to look at the act and how they should know their obligations, working closely with other bodies like the Institute of Directors, for example, the JSE, FSCA, and other regulators. Collaboration, one-stop shop, bringing together data is very important and vital for us to have a full view and a holistic view of what the corporate landscape of South Africa looks like. We also promote innovation and investment. That is one of the imperatives of the Companies Act. And as I've spoken, we bring in aspects of intellectual property law to promote innovation. We are part of a body called the World Intellectual Property Organization at the CIPC, and we subscribe to those particular programs. We have Inventors Assistance Program, what you call the IAP, where we help indigent inventors of products bring it to market, making sure that they have patent protection, and we highly involved in aspects like that. So if you want to contact us, please do so, because we want to promote innovation and South African services and products using the benefits of intellectual property. We also have a multi-channel approach. As you know, we have online services, we have self-service centers in major centers, and we have collaboration partnerships throughout South Africa. One of the reasons is we try to ensure that we reach the length and breadth of all South Africans who want to have access to our services, and therefore able to reach us and to able to interact and deal with us as an organization. There's a lot that we've done, a lot we're going to do, and a lot that we are simply proud of. Shareholder activism is something that we also promoted in the Companies Act, and we see that on a daily basis, where shareholders who have issues with directors, where shareholders have issues among themselves, can come to us and can go to the company, and we try and play that role of trying to look at dispute resolution mechanisms. This is all that we envisage and put in this law called the Companies Act, in order for us to go out and deal with the corporate governance reputation and the landscape of South Africa going forward. And that is it. This is where we are. We pride ourselves on always being an organization that's innovative. We pride ourselves on the fact that we never rest on our laurels. We pride ourselves on continuous improvements. Pride ourselves that we have a skilled and multi-skilled workforce. We pride ourselves on the use of 4IR technology, and we pride ourselves on the fact that we will never, ever not lose sight that our service delivery is to the people of South Africa. So with these few words, I want to thank you all for being with us over this journey. The millions of companies we have registered, wish you good health. We see that you continue to grow those companies. We see many companies fail. What we will also be doing in the coming months is that we're trying to look at the reasons for that and trying to assist, and how we can bring on programs that work with probably the small business department and our mother body, Department of Trade and Industry and Competition, and have programs that enhance that. And we hope that you will sincerely continue to follow us and interact with us on our journey, and will receive the excellent service for years for which we are proud of. Thank you very much, and I hope you enjoy the webinar and the more years to come. Thank you, Murungu. With you.
And I'm definitely sure that will also enhance better understanding of the Act to our employees who are also participants or listening to this recorded webinar. Yes, indeed, the Commissioner highlighted quite a lot of challenges, which is very clear to us that indeed we ran a good race given the challenges and the limited time period. I must say that we as CIPC have done moved very fast, especially in the area of ensuring that we hold directors accountable, as the Commissioner indicated on and cited cases like your SAA and other matters. Allow me to move to our next external guest, a very great man. And if I have to go through his bibliography, I'm definitely sure I'm going to finish your data. But however, let me just highlight some key relevant points that will confirm or link to what we are celebrating today. Our own Professor Tshepo Mongalo received or achieved his BProc cum laude. Professor himself is the former project manager and legal expert of the corporate law reform in South Africa, a project manager 2003 to 2008. Professor Mongalo was extremely instrumental in the development of the Companies Act 2008. His research interests are in the corporate law, corporate governance, securities regulation, regulatory framework design, and social enterprise law. Currently, Professor is also engaged in books, projects with the likes of Professor Michael Katz. Very much important and something that as South Africans we must really be proud of is that Professor has an impact even globally. Professor Mongalo was a contributor to the internationally acclaimed publication by Cambridge University Press entitled Cambridge Handbook on Corporate Law, Corporate Governance and Sustainability. I present to you proudly so our own Professor Tshepo Mongalo. Over to you, whom will be talking to the revolutionary impact of Companies Act on the corporate legal enforcement framework. Over to you, Prof. Thank you for gracing us with your presence. I think Prof is muted. Prof is muted. We can't hear.
Side. Am I audible?
Yes, now you're audible. Now you're audible.
Oh, yes. What I was saying is thank you very much for the introduction, Marumo. And thank you to the Commissioner who spoke very well about the process that we took throughout the Companies Act, in the enactment of the Companies Act. Mine today is not to repeat what he has said, but to concur that at the time when we started with the company law reform, it seemed as if we were all dreaming if we were talking about establishing a company in a matter of a day. Because I remember we had experts from around the world who were saying that experiences in some parts of the world were such that you could incorporate a company as if you are buying a movie ticket. And we aspired to that. And we said that is something that we would like to see. And over the years, I have been interacting with the CIPC just to see how far we are doing in this area. And I must say that I am very pleased that the process has gone a long way to achieving that goal that we entered at the beginning. And therefore, I would like to concur with the Commissioner on what he has said, There may be mistakes here and there, but on the large scale, there is a lot of there is a feedback. I don't know what's going on. Is it only me who's hearing the feedback?
We're not hearing it.
Oh, is it? Oh, okay. No, it's fine then. Mine today is just to do the presentation, a short presentation on the corporate legal enforcement framework. And this is just to see how far the Companies Act has gone, particularly as compared to leading Companies Act of common law jurisdictions with which we share corporate law traditions. I am not going to try to boast, but I will let the legislation speak for itself. For now, I'm going to be presenting. I see that my presentation is not on the webinar, but I will be presenting from my side without trying to affect the flow. But what I would like to talk about today are just 5 issues that I think are very important, because the Companies Act has got a very enhanced enforcement framework that is unmatched anywhere else in the world. And that is because we have actually ensured that the broader corporate purpose has seen its way in the enforcement framework. That is why the first thing I would like to talk about is the broader corporate purpose as a precursor to enforcement reform. And secondly, I would like to speak about common law jurisdiction with broader corporate purpose, but with no expanded enforcement framework. And thirdly, I would like to speak about South Africa as a pioneer in expanded enforcement, and what I call the actionable enlightened shareholder value approach, which is adopted by the Companies Act, and ultimately the Act being ahead of the common law in enforcement. In that context, let me speak a little bit about the corporate purpose as a precursor to enforcement reform. You may be aware of the debates that are taking place now, mainly been spearheaded by the British Academy on the corporate purpose. And this is the very same thing that when we started with our company law reform many years ago, in 2003, we were warned against including any purposive statement in the Companies Act because it was going to lead to proliferation, as they said, of litigation that may actually make our Companies Act unworkable. We haven't seen that, but we see other people now trying to follow the lead that we took in the company law. And this is because we made it clear even at the beginning that corporate purpose needs to be so broad that it must go above the maximization of shareholder value, even though at the time we were seen to be going against the common view or the commonly accepted view. And we said that this is need to be done because we're looking forward as what is going to happen in the world, particularly in the common law jurisdictions with which we share corporate law traditions. Now, in that regard, we looked at the possibility of extending the purpose beyond just being shareholder value oriented. And that is why you look at the Companies Act, particularly Section 7D, you will realize that it points to an expanded purpose, something which many are now trying to take forward. And we are saying that this is regardless of what is said in Section 76(3)(b), which seems to require the board of the directors to pursue the best interest of the company. And the Companies Act has made it clear that the best interests of the company are no longer just limited to the interest of the shareholders, current and future, as the common law requires. But if you look at Section 7B in particular, it reaffirms the company as a means of achieving economic and social benefits rather than just economic benefits. And therefore, the Act puts its proverbial mouth where proverbial money where its mouth is. Therefore, insofar as the common law jurisdictions with which we share corporate law traditions are concerned, we have seen that those two jurisdictions, in particular the US and the UK, have followed suit in terms of trying to legislate for corporate purpose. And the only thing that they lack is that there is no expanded enforcement in both of those jurisdictions. I would like to start with the US. The US, when you want to analyze it, you look at the Model Business Corporations Act. Now, the Model Business Corporations Act is adopted by over half of the states of the US as their primary corporate legislation. And we basically looked at it when we were reforming our law. And one of the things that we see in many of the states that have adopted that is because they have come up with what we call corporate constituency statutes and amended their corporate legislation. In these corporate constituency statutes, what they have done is that they have brought in permissive and peremptory statutes that require companies to take account of constituency other than the shareholders. And majority of them, and actually almost all of them except Connecticut, have adopted permissive statutes in the sense that they do not require, but they permit the directors to take into account the interest of all the stakeholders in addition to the shareholders, although the shareholders take preeminence. But in Connecticut, the directors are required to take into account the interest of the other stakeholders. But the reality is that even though they are required, there is no enforcement, which means that it is directory and not really peremptory as it appears to be. In the UK, the 2006 Companies Act has actually enacted what we call the enlightened shareholder value approach. It too requires the board to have regard to the interests over and above those of the shareholders, but without any expanded enforcement in order to ensure that that is realized. I will just give you an example in the US of a corporate constituency statute. Firstly, the permissive one. I'm using the Wyoming statute here, section 1716.830G, Roman figure 1 to 5 of 2009. It says that a director, in determining what he reasonably believes to be or not opposed to the best interest of the corporation, shall consider the interest of the corporation's shareholders, and in discretion may consider any of the following: the interests of the corporation's employees, suppliers, creditors, and customers, the economy of the state and nation, the impact of any action upon the communities in or near which the corporation's facilities or operations are located, the long-term interest of the corporation and its shareholders, including the possibility that those interests may be best served by the continued independence of the corporation, and any other factors relevant to promoting or preserving public or community interests. That's quite a broad, inclusive statement that pursues that corporate purpose that I talked about at the beginning. The peremptory one is only that of Connecticut, and what it does is that rather than allowing the shareholders or the directors to pursue the interest of those corporate constituencies, it actually requires them to do that. And that is in line with Connecticut General Statute, the latest one was 2009. Now, both the corporate constituency statutes and the enlightened shareholder value approach on the UK are actually taking into account corporate constituencies that were traditionally not considered. Let us look at section 172(1) of the UK Companies Act. It provides that a director must act in good faith to promote the success of the company for the benefit of its members or shareholders as a whole, and in doing so have regard to A, the likely consequences of any decision in the long term, B, the interests of the company's employees, C, the need to foster the company's business relations with suppliers, customers, and others, and D, the impact of the company's operation on the community and the environment, and E, the desirability of the company maintaining a reputation for high standards of business conduct, and F, the need to act fairly as between members of the company. Now, what is quite important here is that while it may seem as if this legislation is a peremptory in nature, what you have to have in mind is that the consideration of other interests except those for shareholders and the company are discretionary in nature, whereas the interests of the shareholders are actually peremptory in nature. Now, although there's quite an expanded view of what the interests of the company are, which include the company employees, the suppliers, the customers, the community, the nation in the case of corporate constituency status in the US, the environment, and the shareholders. The statute imposes a peremptory obligation on the directors only to promote the success of the company for the benefit of its members or the shareholders as a whole, whereas it is actually discretionary in relation to the interest of the company's employees, suppliers, customers, the community, and the environment. And the statute is not complemented by the enforcement mechanism, whether in the UK or in the US. Let's come to South Africa and consider it as a pioneer in expanded enforcement. In this regard, because of the expanded definition of the best interest of the company under Section 76(3)(b), which is read with Section 7D, which I spoke about, as reaffirming the company as a means for economic benefits and social benefits, there are broader corporate constituencies that need to be considered. And this is seen in a number of corporate actions that can be undertaken by those corporate constituencies, in addition to the shareholders. Firstly, it is the proceedings to restrain the company from doing anything inconsistent with the Companies Act under Section 20, subsection 4. The proceedings to have a director declared to be delinquent under Section 162. We have heard the Commissioner speaking about the case of SAA, which is the prime example of a non-shareholder bringing proceedings in order to promote corporate governance among the directors of the company by having the director declared delinquent. The relative litigation proceedings under Section 165 to also allow, in addition, the non-corporate corporate constituencies to bring the proceedings or even continue with the proceedings that are already in process. The extended spending provisions to apply for remedies under the Companies Act, which is Section 157, subsection 1. I'll need to pause a little bit here to explain the importance and the significance of this particular section when it comes to advancement of corporate legal enforcement. This is because for many years, South Africa struggled with whether the class actions in this country are recognized as a matter of law. And the Constitution has, fortunately, through Section 38, when it came into force in 1996, allowed for the advancement of class actions. But as a matter of substantive law, it was only until the cases of the Children's Resources Center and Pioneer Foods in 2013, and the Mongalo versus Pioneer Foods in 2013, that we saw the practical implementation of class actions as a matter of substantive law. But let me just say that the Companies Act has been ahead of the pack. For the Supreme Court of Appeal and the Constitutional Court have implemented the application of class actions in substantive law in these cases. From 2011, section 157(1)(c) has made it clear that as a matter of company law, class actions are allowed, which means that the Companies Act was actually ahead of even our courts in terms of allowing class actions as a matter of substantive law. Therefore, in this regard, we can be proud of the fact that we led the pack, not only in terms of international law, but in terms of the South African corporate law enforcement. Now, this is because South African corporate law introduces something that is called the actionable enlightened shareholder value approach. We call it the actionable enlightened shareholder value approach because in addition to considering non-shareholder corporate constituencies as a matter of statutory provision, it allows those constituencies to be able to enforce the different corporate actions. And the expanded purpose is therefore complemented by corporate actions, as we have seen in the Organization Undoing Tax Abuse versus Miani, the December 2019 case that is used as the best example of a non-shareholder bringing action to enforce corporate governance in a company. Now, in this regard, the corporate law enforcement under the Companies Act is actually going even ahead of the common law and has actually dispensed with very conservative rules, standing rules that we see under common law. And the Act does not just pay lip service to corporate purpose, but it basically sees to its implementation. Now, the question that many people have been asking is that, is the Act ahead of the common law, or is the common law still an interpretative factor when it comes to determining what the best interests of the company are? And the concept of the best interest of the company is found in section 76(2)(b). Now, it would appear as if when the Companies Act is read as a whole, particularly in relation to the purpose clause and the actionable enlightened shareholder value approach, this interpretation of the best interest of the company is no longer congruent with the best interest of the shareholders, current and future, as it is the case in common law. Therefore, the common law has been overtaken by the statutory interpretation of the proper purpose clause. And therefore, the actionable enlightened shareholder value approach supports the new meaning of the best interest of the company as being the interest in line with the corporate purpose, not only the interest of the shareholders. In this regard, I think we have actually set a stage for those who are now considering corporate purpose, particularly in the UK and the US, to say it needs to be followed by the corporate legal enforcement framework that is reformed in the same way as it has been reformed in South Africa. I would like to thank you.
Presentation. I must say that you really shared with us also the global impact in terms of sharing the USA and the UK perspective. And for me, I'm also very much touched by clear understanding in terms of the economic benefit and social benefit. And also perhaps to thank you for sharing with us to understand the allowance of class actions, and in terms of saying the Companies Act is ahead of the courts as well as common law with clear explanation of what is understanding. But the webinar is recorded. For those who may be more interested in understanding, there was a lot of information, value-adding information, and very educative. But I'm going to allow questions to the Prof through my technical team, Rosani, for any captured questions for the prof, for anybody who may be wanting to get some clarity or questions. Rosani, any questions? On Facebook, I don't see any, but from your side, Rosani, can you confirm, are there or any staff member or colleagues or any participant who may be interested in asking a question to the prof? Please, you are allowed to do so, because after prof, I'm going to release our honorable professor and focus on our two remaining internal speakers, which will be Advocate Krista Klo and our expert. Rosani? In the absence of any question, I don't see them coming. It means really it's a real prof. You see, we can't ask questions, prof, because you even referred us to the Roman figures. We could feel that, no, it's going to be related. It was really interesting. Thank you very much. Much appreciated. We will continue to engage you. I think this was just an eye-opener that we need to, especially us internally, to try and enhance our understanding and continue this progress of making an improvement. And I'm happy to hear you telling us that, yes, we have made a great mark. Thank you very much, and keep up the great work. We're proud of you as South Africans. I thank you. Prof is muted, Rosani. Continue, Prof.
Oh, yes, I was saying that it is really an honor for me to participate in this milestone of celebrating the 10th anniversary of the Companies Commission and the Companies Act. And I feel honored that I have been invited to talk to you. I wish you all the best for the remainder of the webinar. I just wish we had a cake and there was no COVID and we could actually interact. But I really wish you all the best and the good work that you're doing.
Thank you.
Thank you very much.
Thank you.
Thank you.
Our next speaker, it's our internal best advocate, Krista Klo. At the end of the day, the professor gave us the bigger picture. And in terms of implementation, the production house is done internally. She'll be sharing with us the achievements and the new way of transacting. As at the end of the day, we all need to accept that we are the enablers of ensuring that entrepreneurs become actively involved in the economic mainstream. Allow me to present to you our honorable advocate, Krista Klo. Over to you, Krista.
My apologies for that. I thought I pressed the unmute button. So just to start again. So I also remember the days when Silas alluded to whereby we started and we came into the office and we had files stacked from the floor to the ceiling. We just couldn't keep up with all the processing of new company registrations. As our commissioner has indicated, a lot of things went well and there's a few things that did not went well. I remember in 2014 when we introduced our e-services functionality whereby for about a month, none of us actually slept in order to make sure that e-service was functioning. There was the point in time where we had to shut down annual returns for a month in order for urgent correction of the system in order to allow the filings that came in. But those are the histories. When we look back at that point in time, we all felt very frustrated, wanted to pull our hair out, but we've made it. And we have grown through all of these experiences, as the Commissioner has indicated. We have grown and matured as an organization through all of these experiences. So, yeah, as I said, most of us have been here for a very long time. I've been now here for 15 years, the Commissioner even longer, Silas even longer. So the history runs deep within CIPC. So I'm going to now go into the ease of transacting. As the Commissioner has indicated, there was a lot of fundamental changes that occurred within the Companies Act that enabled this. So a lot of these things that I am going to say is going to be a little bit slower and a little more in detail to what the Commissioner and Prof has indicated. So we have to understand that the Companies Act was actually built on foundational principles in order to allow for electronic transaction, the ease of filing. And one of the concepts is if filing and keeping your information up to date, the registry function is easy, compliance becomes easier. So that's why we have such a hard focus on registration for such a long while. And for the last couple of years, we have moved into regulation because the ease of processing all these applications has made it possible for us to focus. And also the data collected over the years is irreplaceable in order to run our compliance and enforcement functions. So the Companies Act was actually defined onto 5 economic growth objectives: simplification of registration, simplification of filing, simplification of doing business, flexibility, we meet you where you are, efficiency, transparency, especially under the 1973 Act, where a lot of information regarding corporate entities were regarded as private. In terms of the new 2008 Act, there is no such thing as privacy or private information. Everything that you file with the CIPC is public information because the public has a right to access that information. And then also predictable regulation. Some of the notable changes the Commissioner has already alluded to. I'm just going to briefly run through it. And all of these enabled us to actually be where we are today. So as Prof indicated, that we moved from a creditor-orientated piece of legislation to shareholder orientation. We've done away with capital maintenance. Those that are new to the area, capital maintenance was you had to keep a minimum amount of capital all the time for the administration of your company. That has fallen away and was replaced by the solvency and liquidity test, meaning you have to see this, what the solvency and liquidity position of the company is when major decisions are taken. We've done away with the ultra vires rule, limiting the business activity to what is stated in its MOI. We've done away or replaced judicial management with business rescue. We've got a lot of high-profile cases, and all these high-profile cases actually emphasizes the importance and how business rescue actually works. So media coverage over big corporate matters actually allows for more consumer understanding of these processes and what they aim to achieve. I'm just quickly going to run through. We've already gone through the governance and also the enforcement abilities that was brought into the 2008. As the Commissioner has indicated, CIPC is just one of the 4 major regulators or administrators of the Companies Act. We have that role together with the Takeover Regulation Panel, the Companies Tribunal, which is new, as well as the Financial Reporting Standards Council. So, as the Commissioner has indicated, it was quite a 10-year journey just to draft the legislation itself and also to implement it. But what has to be understood before you actually can draft a piece of legislation, there is a guideline document that's prepared that forms the framework of the consultative process. And in this proposed guideline, there was proposals that needs to be met within the framework of this development. It was simple, comprehensive, and accessible, must be accessible to business people and their advisors. There must be simplicity in language and grouping of subject matter, simplification of processes and lodging of documentation. My presentation is focusing on that. The core principle is facilitation of electronic lodgement and communications, very, very key. And to be quite, I think that was very futuristic when they actually drafted. The Companies Act was drafted before the introduction of the smartphone. So that was very future looking. The Act and the regulation should form a whole and must be combined. And companies should not be overburdened with unnecessary rules and regulations. There is emphasis on accountability and transparency. Company structure should enhance efficient allocation of resources by creating a framework for businesses that require transparency and harmonization of international jurisdictions as far as possible. And I think we have achieved that and actually more advanced in some areas than other jurisdictions. The Commissioner actually went very into detail regarding the purpose of the Companies Act. I'm just going to allow a couple of seconds to be scrolled through the presentation slide that deals with the purpose of the Companies Act. In order for you, when you view this at a later stage, you can refer back to it. But I'm going to focus on creating a flexibility and simplicity in formation and maintenance of companies. So one of the key things that needs to be understood is in order for us to allow for all of this efficiency and electronic processing of information, one key thing that was brought about is our right as CIPC to automate, right? So we can automate, move from a paper to an electronic. And the Companies Act has got a few principles and indications that allows us for this. Again, the Companies Act was built on electronic communication and filing. So examples is companies can have meetings electronically. Who would have guessed COVID? And allowing of meetings being done via these mediums and Zoom and MS Teams to actually be legitimate meetings. Annex 3 of the Companies Regulation also states that you can take any form that was published and convert it into electronic format and then allowing that for the filing of information. And I think we've been very successful in doing that. People ask us, but should I fill out a form and then submit it? We have taken the published form, converted it into a user-friendly guide onto all of our portals, our mobile app, our e-services, our BIS portal, that you complete and you submit the information. If you compare the form to the electronic form, you'll see there's slight differences. We have added a few things, changed a few wordings in order to make it more usable and actually more understandable. It's no use we provide a copy of the total form and it's not understandable by the user that actually needs to submit the information to us. The other thing is that it's also, if it's the Companies Act provides for, that it's sufficient for any document, record, or statement that's required to be retained by the company to be kept in electronic format. So, for example, you can actually keep your accounting records in an Excel spreadsheet. You can keep your minutes onto a safe storage on a server, for example. You don't have to print it out into a paper and store it in a file. So you can keep all of your records electronic as long as it's easy to extract and to redistribute or to provide to the next person who needs it. Also, what's the key is what we have allowed for in terms of the Companies Act is signing. A lot of documents are required to be signed. So Act actually provides us anything that the ECT Act allows, we can adapt for the purposes of filing of information with the CIPC. And we've done that quite successfully. A lot of you don't even know that when you log into providing your customer code and password, you're actually signing the document that you are going to be filed. When you receive an OTP, the OTP is your signature on the form. We also allow for fingerprints at our SSTs. Your fingerprint, which is a biometric, is regarded as your signature. The only thing that we have to do is to publish a Government Gazette notice as to state what we regard as a signature for filing of our documentation. So you don't actually even feel the introduction that you are signing a document, because we've made it so easy for you to do that. Further, we can establish any system that allows for of electronic means to allow for the facilitation of the automation of names. We have done 40% of all company name reservations that are submitted to us are actually done by our computer system that has got detailed rules and requirements. Those that the system cannot automate is actually being pushed through to the back office. That's how we've been able to move name reservations from 3 to 4 days into 1 day. 40% of all name reservations are done by an electronic system that we monitor and control. Incorporation and registration of companies. We've done that via e-services, the mobile app, the BIS portal, and our new K2 new e-services platforms. Any document can be filed electronically. We've even done that for the changing of share information on companies. Then we can also accredit any existing system for electronic filing. We've done that with the XBRL system. My colleague Henny will actually provide you with more detail on that. It was a very interesting road with the XBRL. And as I stated, we can do that by publishing a notice in the Government Gazette. We can even stop the filing of any channel by giving notice in the Government Gazette that we only accept documentation in this specific electronic format. So we've got a lot of flexibility that was provided in terms of the Companies Act. Without it, we will probably still be sitting with mountains of files trying to be interfiled. The next element that we need to understand what the Act provides for is called substantial compliance. In order to make it easier for the business owner, it basically requires, if the document that you file with the CIPC substantially complies, but all the major little elements that is needed, all the necessary information, we need to accept it. And that is perfect. That's the ability for us to adapt the form slightly in order to meet consumer usage and expectations. But the downside is that with automated systems and the fact that we are a highly audited organization, everything within CIPC gets audited, from the Auditor General to our internal auditors, and everything needs to meet a certain set of standards to make sure that we provide consistent and fair processes. So when your application does not meet, let's call it the cookie cutter of the system, you can actually log a ticket for the line manager to consider any deviation. And then the deviation will be considered based on certain framework that we have internally, and then you'll have permission in order to adapt or change it. So if you don't meet the set requirements on the systems, you're more than welcome to log a ticket and give us reasons why not, and then we'll look at and adapt and indicate how you can proceed further. Then what the Commissioner has also alluded to is the standardization of the MOIs, the Memorandum of Incorporation. So I'm not going to go into that. That was one of the biggest elements. If it wasn't for the standardized MOI, the standard rules for a private company or an NPC without members, we still would have gotten mountains and mountains of documents and rules. So that also was a key thing. About 93% of all new company registrations are actually what we term as short standards. Short standard private companies and NPCs without members that follows this MOI, short standard MOI. So it was a huge success in order to do that and to provide this ease of registration. Then another thing that was introduced in terms of the Companies Act, you can file your name reservation with your new company registration as one pack. It looks as one pack, but again, it's a little bit of a trick. At the back end, the system splits the information. It gets processed by the dedicated teams and systems, and it gets put back into the end for you. and you don't even see that it's actually two processes. We've collapsed it. And very interesting, we have actually followed this approach in a lot of our system design in order to make compliance discrete, is that we have collapsed a lot of the forms and requirements into something that looks like a single form or document. But there is a lot of hidden information and business rules and information collectors that collect all of these things for you. That's also why we've been able to do with such registration for tax return and central supply database. All these systems contain similar information or require similar information. We have maybe just added one additional field on our side, and we've triggered the information already for that government department, and we push the data through to them. So this substantial compliance and taking the form to electronic format has provided us a key component in order to collect information on the registration of a company or any of our forms and push that then through to the other regulation within the government sphere. So it makes your life easier as a small business owner. So as the Commissioner has alluded to, we have got a multi-channel approach. All of this has allowed us to be more flexible. I remember in the days when we just started, we used only one way of contacting, or you could either phone us or visit us at our head offices. Now you can get your information on our website, Facebook, Twitter. We've even now with Telegram, CIPC Telegram, you could actually register there. So when we issue notifications, you actually get access to your phone immediately. We've got our inquiry system, online inquiry system. So we moved away from email inquiries into a system that provides so much benefit. An email, clients want to discuss things and they send it to 5 people, and then we don't know who needs to attend to it. Also, with an email, there's a delay because we cannot attend to it immediately because we've got other functions. If you assign it to a staff member or a colleague, you don't always know when they've responded. On the ticketing system itself, it's got the benefit that every inquiry is consolidated into a single system. So for us as CIPC, we can actually go in, extract information per a specific queue. We can data mine it. We can actually assign service standards. We can tell you precisely how many tickets a team member has responded to. What was the quality on the responses of that ticket? We can work out what's our service standard on answering specific relating tickets. That has added a lot more benefit in an email, for example, where you can't have that type of information for reporting, transparency, and accountability. Also on an email, if you send it to me, and I'm unfortunately on leave, Silas don't have access to my mailbox. On the ticketing system, more people have got access to the same queue of information and can provide quicker assistance. Sorry, I love the ticketing system. It makes my life easier and manageable. Then on the application side, as we alluded to, and especially on the Commissioner, we have got great success with this. We have got our self-service terminals. So meaning that we can actually get our services to you in the rural area. You don't have the days where you had to get into a car and travel to the nearest intermediary or come up to Pretoria for assistance. You don't have to do that anymore. You can access us literally on your phone or your device or via any of these channels. Or if you want a face-to-face assistance, you go to our self-service centers. They will assist you there by actually providing your fingerprint. With providing your fingerprint, we verify you as with Home Affairs, and it improves quality. We've got the BIS portal. We've got our website, our e-services. A lot of our systems are email, which is also electronic. We are going to phase away emails because our mailboxes has become extremely heavy. So all of our services are going to migrate away from email into the other channels. We have got CIPC Mobile. We've got registration via a bank. We had the third-party model, which we discontinued because of low usage. Again, we've learned from it. We've taken some of the learnings and implemented into our other services, for example. So all of these services, the objective that we have is here, as the Commissioner stated in his introduction, is we want to meet the business owner where he does business. We don't want the business owner to come to us and stand in line. We want our services to be available to him where he wants it and needs it. We also want to provide it to them directly, not to use the services of intermediary unless it's needed. Please note that some documentation requires more detail. So if you want to have a customized memorandum of incorporation with customized rules that your shareholders have to buy in, best to go see an expert in that area to do it properly, because it does bind all the parties. It's in order to save cost. We want trying to provide our services 24/7, 365, meaning even if we are not here, you can access our services. This was brilliant during the hard lockdown in April last year. We were able to actually keep running certain services. We had limited name reservations that was allowed for because of the automation. New companies could continue to be registered via our BIS portal, which was fully automated. Those systems we were able to maintain even remotely from home. That is the benefit. You can also wake up at 2 o'clock, have a brilliant business idea, and register your business. We're also making in our IP environment registration of your IP rights also much easier. When you have that idea, you can actually start immediately. These automations also allow for integration with other government departments, as we have indicated. And also, one thing that needs to be noted is that because we are automating, some services are more automated than others. So, for example, on new companies, you've got 8 service available channels, while on some areas you only have 1. We are moving our services into multi-channel. So shortly, something like, for example, a deregistration that can only be emailed. We're actually looking into that to automate it. You'll be able to go onto the BIS portal or new e-services and actually apply there for your deregistration. We will link it up with the relevant government departments as they come online with us, which actually will bring down the period to actually get you finally deregistered if you decide to close down your business. So all of these are happening, and it's continuously happening. As the Commission said, some services work, or it works initially and it does not, and then we'll close them down, but we'll keep you updated through our website. So in summary, a long discussion, we are doing away with paperwork. We don't really like paper. When we see paper, we actually don't know what to do with it, but give us a moment, we'll figure it out. So we are doing away with paper in order for you to provide real-time registration of company information and maintenance and the updating of the information. So thank you very much. I hope that was insightful and interesting.
Your presentation, the 1973 Act was really cumbersome with lots of uncertainties. You made mention of the ultra-virus and other provisions of the Act. One can simply say now that the Act that we are celebrating, the 10-year anniversary of the Companies Act, we need to be very proud of what we have achieved, because it's very clear that simplification it's really key in this regard. I'm going to move to our last speaker of our program for today, which will be our Mr. Enifel Yun, whom is a XBRL specialist from our unit. He reports to Mr. Joey Mateka under the Corporate Disclosure and Regulation and Compliance. Over to you, Mr. Eni.
Thank you, Marumo. And yes, good morning, everybody. It is my privilege to talk about one of the innovative initiatives of the CIPC, as the Commissioner has mentioned in his opening statement, as well as mentioned by Krista. the CIPC has really made inroads with regards to technology and implementation of technical solutions. So I'm going to talk about XBRL specifically, which is one of the major technology initiatives that the CIPC embarked on during the last couple of years. Let me just get my slides up and running. I'm going to talk about the operational efficiencies and regulatory effectiveness through digitization, and specifically the XBRL technology that we've implemented. Just a high-level summary of the content that I'm going to talk about. I want to touch on digitization, the fourth industrial revolution, and the Companies Act, and how those three come together. In more specific terms, I'm going to talk about the XBRL program of the CIPC, touching on what is XBRL, why did the CIPC implement XBRL, how does it work, and what was the outcome of the program. And then lastly, I'm going to touch broadly on future developments for the CIPC and the larger regulatory ecosystem and how XBRL relates to that. I want to start off by a quote from the current strategic document of the CIPC, which mentions that digitization remains key for CIPC in preparation for the fourth industrial revolution. Now, what is the fourth industrial revolution? That is something that's very much on the radar of government in South Africa. And I want to mention a quote on the website of the Presidential Commission on the fourth industrial revolution. The definition of this industrial revolution is not quite set in stone, and the technologies associated with it are moving targets whose true value will reveal themselves to us as we explore them. But specifically, it mentions that, however, the fourth industrial revolution can be broadly defined as an integration of faster, efficient, and intelligent technologies. Now, there's a lot of technologies that form part of the fourth industrial revolution, but I want to focus on how that fits into the CIPC and specifically on the faster and efficient aspect of that. Now, the quote from Regulation 35A of the Companies Act specifically mentions that the Commission must establish a system to select and review a sample of financial accountability supplements, audited annual financial statements, or independently reviewed annual financial statements that have been filed. Now, what is XBRL? XBRL, the acronym of XBRL stands for Extensible Business Reporting Language. And XBRL is an open international technology standard for digital business and financial reporting. In other words, it's a mechanism for exchange data between organizations and a way to capture that data. Now, management of XBRL is by an international not-for-profit consortium, which is called XBRL International. XBRL International has many jurisdictions across the world. There are more than 50 jurisdictions in different countries. In South Africa, we've got a local jurisdiction, which is called XBRL South Africa. And their purpose is to promote the use of XBRL or digitization through regulatory bodies, government agencies, as well as private organizations. Now, XBRL provides intelligent context to data via taxonomies. Now, with a taxonomy, we only mean a data dictionary, which define data elements in a barcode-like fashion. Whenever you buy something from a supermarket, say you buy a can of beans, there's a barcode on that. When that gets scanned, the system behind that immediately has a lot of information about that item that you buy. For instance, the price, maybe the weight of the item, who's the manufacturer, etc. All of that is back in a taxonomy or a data dictionary. And the purpose of a taxonomy when it comes to data for annual financial statements, in the case of CIPC, is to remove ambiguity from financial concepts. For example, what exactly is meant by revenue? Many companies may, when they report on revenue, have different ideas how they define that. Some might call it sales or income or revenue, and is it gross income? Is it net income? taxonomy aims to define exactly what the CIPC requires by a specific data concept. And those data concepts are aligned with accounting standards. For instance, the International Financial Reporting Standard, or IFRS, or GRAP as well, which is a generalized recognized accounting practice. So, and it also, XBRL provides, like I've mentioned, an electronic data exchange between organizations to make it more efficient. Krista mentioned a lot about we want to move away from paper and even other methods of electronic filings like PDF. So before XBRL, what led did the CIPC, or why did the CIPC decide to go the route specifically of XBRL? We didn't have a proper handle on volumes. We received tens of thousands of annual financial statements on an annual basis to be processed by a very small team of investigators. The data that we received previously were not structured, with no back-end system in place. Annual financial statements were received in PDF format via emails. There was no standard labeling of data elements of IFRS accounting standard, like I mentioned, the example of revenue, which can be ambiguous. And we also didn't have an automated analysis mechanism for reporting. So we had very low efficiency. It was very labor intensive and it was prone to errors. And because of this, there was very little regulatory oversight. We were only reactive and not proactive with low effectiveness. We did receive many sets of financial statements in PDFs, but it was basically just like a register. We just received that and we couldn't do much with that, especially because of the high volumes, because there was no mechanism, system in place for proper analysis. So after XBRL, when we implemented that as technology standard, what improved at the CIPC? We now have automated validation and analysis of financial statements. XBRL is structured within a system and there's a data warehouse. Now, I want to mention when we receive annual financial statements via our online e-services portal, there's about 80 validations built into the system at the point of where we receive that set of statements. So the system can automatically check for 80 different tests. For instance, mandatory data elements that are required that we must receive in every file. There's also calculations, for instance, totals that need to add up. So if that set of statements doesn't pass that set of validations, it's rejected. And the user of that system, the filer uploads, it gets messages on the screen and also via email with what's wrong with their filing. So this eliminates the filers to submit filings to the CIPC that is basically garbage, if you can put it that way. We already got a stamp of approval to some extent and of quality the moment that file is received. The validations that we've built into the system are based on the regulations of the Companies Act and the accounting standards of IFRS and GRAP, like I've also mentioned previously. We've got improved turnaround times in investigation of non-compliance because we now have a workflow system. It's not just a matter of receiving the financials, but on the back end, we've got a system where the investigators do sampling. And they can drill down into those set of financials that's already past the first tier of analysis when the statements were uploaded. We also have greater collaboration with filing entities through constant engagement on queries. So when something is picked up, either by the pre-validation of the system, there's communication with the filers. Krista mentioned our online query system. So it often happens that when a filing is not accepted, that the filers communicate with us on the errors that the system came up with, and we can liaise with them and assist them to fix those errors and fix their filings and submit accurate set of statements. And also when the investigators look at the files that did pass the validation and something is not right with that set of statements, the system makes provision for sending letters and we communicate. So there's a lot more collaboration. And because of this, we've got better reporting on consolidation of financial reporting as well. We've got a business intelligence system, which can draw some basic statistics. We can do proper analysis of trends and ratios. For instance, we are now in the 3rd year of receiving financial statements through XBRL. So we've started to build up a repository, some history of filing. So now we can go back over the last couple of years and we can see what happened to a specific company in terms of their financial soundness. We can also compare companies with other companies and even industries with other industries. And we can get a bird's eye picture on the economy as a whole because of our system, which we didn't have previously. I want to touch on the journey. How did we get to this point where we've implemented XBRL? It all started in 2013 with the ROSC report, the report on observance of standards and codes, which was issued by the World Bank. And that report specifically mentioned XBRL and the benefits of XBRL for the economy of South Africa, because it was already back then started to become a worldwide best practice standard. And the CIPC, since we are a central regulator, just about every organization in the country starts off with they start off by registering at the CIPC. It's also then, depending on the type of organization, that they also need to report to other regulators. If you're a bank, you report to Reserve Bank. If you're, for instance, a broker for financial services, you report to the FSCA. But all starts with the CIPC as central regulator. So during 2016, with the help of XBRL South Africa, a business case was developed. We looked at strategy and planning the program to kick off with XBRL technology in South Africa through the CIPC as champion. During 2016, the development of the taxonomy took place. That was a starting point. And that taxonomy was aligned with IFRS, as the Companies Act also stipulates. During 2017 and 18, development of the technical portal for filing took place, and also client-side software. Now here I want to distinguish between the portal of the CIPC, which is the entry point of the financial statements, how the CIPC receives that and how it gets uploaded to the CIPC. But also it was necessary to have client-side software. So all the entities who were required to submit financial statements needed some kind of tool on their side in order to file the financial statements. I will say more about that a bit later. During 2018, we launched a pilot for testing purposes, a pilot program to make sure that our system that we were developing at that stage is robust, that it works, and that it's usable for all the client entities. We started the pilot with high-profile listed companies. We approached a lot of listed companies, and we're happy to say that we received a lot of participation. Large regulated entities, exactly 60 listed companies participated in a pilot. And during that 3-month period of the pilot testing, a lot of technical issues were sorted out, a lot of regulatory and even accounting related questions that came up were addressed, and we made sure that the system that we implemented were refined. And then on the 1 July 2018, we went live with our XBRL system. We launched that through an event at the JSE where the Minister of DTI was the keynote speaker. I mentioned client-side software, so it's important to talk about the role of software service providers. We created the software service provider panel to assist the CIPC with client-side software. Now, we realized from the start that it was important to cater for all role players. You've got your very large listed companies. On the one side, they may have had already significant software and systems in place, and they didn't want to go through tedious steps to be able to provide financial statements. They might have had all the information already in back-end systems. And for those large players, it would have been convenient if they can just click on a button from their current systems, or they can implement a system that also has back-end functions. And a spin-off of that is just to produce a set of annual financial statements that's compliant to the stipulations of the CIPC that they could simply just upload. But we also have small and medium enterprises who do not have sophisticated system in place. So the purpose of the software service provider panel was to address the needs of all those role players. So we currently have 23 software service providers that we evaluated. We evaluated the software and the services, and they are recommended, and there's a list of them on the CIPC's website. Now, we do not officially endorse software service provider software service provider companies. We only mention on our website that we have tested the software and we do recommend that. And they cater for the whole range. There's literally software solutions available which a filer can type their financial statements manually on a web portal and just produce an XBRL file, or they can have existing PDF file sets of statements that were audited and just convert that into the right format. And it starts with prices lower than R1,000, and also there's, like I've mentioned, very sophisticated system which is a lot more expensive. Current utilization of the XBRL to CIPC and what do we use it for? I've mentioned briefly, we've got a workflow system for individual analysis. Previously, investigators had to manually go through thousands of PDF files and it was impossible to do proper review of that. Now our workflow system manages that in the back end. It can route sets of financials to different individuals, for instance, from an investigator to the head of the department, back and forth, etc. People can comment on that, and there's collaboration in the XBRL stream. The people working on the financial statements through the workflow system to do proper analysis. I've mentioned the business intelligence on consolidated data, which is a very useful tool. And over time, as we build up a repository, this will become more and more important. We will get a much better picture of what's happening in the whole economy of South Africa, because we can compare industries, we can compare trends and determine ratios. And then we also start to share our data repository that we started to build up over the last about 2.5 years with other regulators and government agencies, and even private investment companies. It started to become evident that we are building up very useful data that can be shared with other organizations. Yes, and I also want to mention the trends that we can determine per industry and the economy as a whole. It also serves as an early for instance, the Steinhoffs that I think the Commissioner also mentioned, we can see through our system now when trends are going wrong, and it's an early warning system if we look at the financial statements and the history of that through our system. And it's also possible to assist data aggregators who's got investment clients to make wise investment decisions based on the history of a specific company or even an industry, because of the data repository that we built up. How does XBRL currently make a difference at the CIPC? It contributes significantly towards improved policy execution. We've got improved compliance. Currently, we've already received more than 37,000 successful filings. And there I want to mention the e-service system that Crystal also mentioned. We're still improving on that system, but the submission of annual financial statements is part of the annual return process. And the annual return process cannot be completed online unless a set of financials has been submitted. Now, there are different regulations in Companies Act that determines when a set of annual financial statements need to be submitted and when a financial accountability supplement is to be submitted. For instance, the public interest score, I'm not going into the details of how that gets calculated, but the system at least forces now that an entity who provides annual returns must either submit a FAS or a AFS. And we're in a process to improve that system to calculate exactly when a AFS and a FAS is required. Now, I need to mention that the reasons, or rather the regulations that determine whether a company must submit a FAS or a AFS can change from year to year. For instance, if a company 1 year does a lot of business and is very successful, they may need to submit annual financial statements. The next year, they may fall outside that bracket and only submit FASs. So we're in the process to improve the system to exactly determine upfront so that companies or entities know exactly which route to go through our online system. We are identifying early signals of sector distress, like I've touched on as well, and it helps us with proactive enforcement. And then how do we monitor and enforce the stipulations of the Companies Act? The implications of non-compliance with filing of annual financial statements in the XBRL by qualifying entities means that entities that don't comply with submissions will be investigated, and they can be issued with a notice of non-compliance with certain provisions of the Companies Act, and failure to act in accordance with the compliance notice will result in possible court litigation by the CIPC, possible probation of delinquency of directors, an administrative fine of up to 10% of turnover, and even a deregistration of the entity with the CIPC. Ingredients for success, or the recipe that we followed that we noticed that worked for us to implement XBRL successfully. It was very important to get buy-in right from the top. So there was government sponsorship by the Minister of Trade and Industry. The legislative mandate, the Companies Act, like I've mentioned, mentions that a system must be in place for analysis or for submission, rather, of annual financial statements. So we just used that stipulation in the Companies Act and specified that the system that the Companies Act mentions will be via the XBRL solution. We started off by building a taxonomy. That was the foundation, because we needed proper financial standards, audit, the IFRS reporting standard. And then the next step was to build a robust and technical sound solution. And right through the whole process from the start, we realized the importance of change management. Now, we went through a lot of effort to communicate the program, the benefits of that, the reasons why and how, both to sell it internally to external stakeholders in the CIPC and also to external parties. For instance, I've mentioned partnerships with software service providers. We've liaised a lot of professional bodies, for instance, SAICA, to buy into the process, to help us sell the whole program to the filers out there, the entities we are regulated. So buy-in was very important, and we did this through numerous, there were articles written, there were webinars held, we went on road shows, there were TV and radio interviews, and on a continuous basis, still to this day, we keep on selling the XBRL program and implementing change management. And then we also received international recognition for innovation. I just want to mention, in February, we had a conference, an online conference or colloquium, and there was a lot of interest, hundreds of people attending that. And we also received an international award for innovation. On the 31st of March 2021, the CIPC was awarded with an award from the Corporate Registers Forum, which is an international organization. And you can see the picture here. The award was received by Mr. Joey Mateja. He's the head of corporate compliance and disclosure regulation. He's the owner of XBRL at the CIPC and directing that very strongly for the CIPC. But we're still aiming higher. So what are the future development and improvement plans that we have for XBRL? Now, when we implemented XBRL in 2018, it was based on IFRS accounting standard for 2016. But since then, we've kept abreast with the latest updates of IFRS, but as it gets released annually by the International Accounting Standard Board. And currently, we're busy with a project to update our taxonomy with the IFRS 2021 updates. And we've also implemented the GRAP taxonomy last year, 1 October, but that was only on a testing basis. GRAP will become mandatory on 1 October 2021. So on 1 October this year, both GRAP will become mandated and the latest IFRS 2021 updates will be implemented. We are in a process to develop a new e-services portal. I've mentioned previously the difference between FISs and AFSs, so it will now verify exactly. In the past, we noticed that some companies who were actually supposed to submit AFSs submitted FISs, but the new e-services portal will eliminate that. So we will for sure know that we do receive all the annual financial statements that are required by the Companies Act through XBRL. We are also planning a new subscription portal for data sharing. Krista mentioned that whatever was submitted to the CIPC can be made available in the public domain. So it will be possible in future for a user to register on a portal, subscribe to the portal, and to obtain a set of financials of a specific specific organization. And then we're also moving into the direction of digital assurance. We are exploring technologies for auditing the electronic file. At the moment, we receive together with the electronic XBRL file normally as a supplementary document, just a signed off document in a PDF format. So currently the technical file, the XBRL file is not audited yet, but there's potential for doing that electronically. We're looking at third-party digital signatures or certification as one option, and even as blockchain technology in future. And then what's our vision for the future beyond the CIPC itself? And that is SBR. And SBR is an acronym that stands for Standard Business Reporting. The principle there is report once and share many and collaboration. Now, we've got different regulators in South Africa and government agencies who can potentially share the same set of financials. There's, for instance, the Reserve Bank, who look at capital adequacy for financial reporting. There is SARS for tax filing and reporting on financials. There's the FRAC for financial reporting compliance. There's Stats SA for aggregation on industry financial performance data. There's the FSCA for financial reporting in terms of the FICE Act. And then there's IRBA for financial reporting in line with audit requirements. Now, the CIPC is the champion who started off with XBRL in South Africa, but the potential is that the same set of financials can in future be shared by all these regulators. At the moment, organizations who report to more than one regulator often need to submit a different set of statements according to a different format. So it's duplication of work, duplication sometimes of the same information, but looking a bit different because the format is different. So the idea is to bring all these regulators together, and maybe there can be a central hub in South Africa. It can be at the CIPC, or it can be done in a different way, where all companies who need to report to some regulator or government agency can submit the same set of financials. XBRL South Africa is very much instrumental to drive that, to drive data harmonization, to bring the requirements of all these regulators and government agencies together. There may be unique extensions and unique differences, but the idea is to eliminate duplication, to make life actually easier for all organizations out there who need to report financial statements to some regulator government agencies. And there's also the potential for a regional way, for instance, SADC countries. Now, we're not there yet, but that's where we can imagine that XBRL can take South Africa through standard business reporting. Thank you. That was just a quick overview of the XBRL program that the CIPC is proud to have implemented. Over to you, Marumo.
Mr. Enifaliun, I must say thank you to your team also. Very true, as per your presentation, XBRL, it's one tool that took this organization to another level, both locally and internationally. And we are proud of the award that you won. You made mention of the electronic data exchange for financial accountability, the benefit of a structured data, also the regulatory function. Thank you very much. I would also like to use this opportunity to request attendees that they can send their questions on the CIPC Facebook messenger system for a direct reply. As you can see, time is not also on our side, but that we definitely show that whatever questions that they may have, they will get a direct reply. I would also like to, on behalf of the Commissioner, thank Professor Mongalo, who participated, and also to thank especially the hardworking staff of CIPC. The Companies Act 2008 would not have made it on its own. We needed good leadership, the innovative team that we have at CIPC, the ICT, and as well as our support teams in terms of finance and other role players. I would like to say thank you very much also to my team from the corporate education who made this possible. And I think together as a team, also not forgetting to thank the Krista from the production unit in terms of sharing with us our new way of transacting. Everybody played a role. Thank you very much. It also shows that as a team, we can make things happen. I thank you. And we look forward to, please look forward to having other webinars similar to this in terms of celebrations. And next time, I apologize, I will avail a virtual cake. I thank you all.